Vice President Fielder, are you on?
That's affirmative, Mr. President.
Commissioner O'Donnell?
Yes, sir.
Commissioner Bukacek?
Yes, Mr. President.
All right. Good morning, everybody. Time is now
Good morning.
9:30 a.m. Today's date is January 9th, 2024. This is the time and place for our regularly scheduled business meeting. We are here at the offices of the Montana Public Service Commission in the Bollinger Conference Room. I call this meeting to order. Would my colleagues join me in reciting the Pledge of Allegiance?
United States. Nation.
All right. Thank you, colleagues. I would note for the record that Commissioner Pinocci and myself are present in the Bollinger Room. Vice President Fielder, Commissioner O'Donnell, and Commissioner Bukacek are participating online, so we do have quorum this morning. Before I call for public comment, I just want to wish everybody a Happy New Year and hope you had a great holiday season. With that being said, the Montana Public Service Commission welcomes public comment on any matter that is on today's agenda or on any matter that is within the jurisdiction of the Montana Public Service Commission. Are there any public commenters in the room? Well, we do have one. Please come forward. State and spell your name for the record. And welcome. Happy New Year.
Happy New Year. Sarah Norcott, last name's Norcott. I'm here appearing today to give public comment in my personal capacity on the matter that's on the agenda related to railroad safety. I live out in the Scratch Gravel Hills and have to cross over head lane potentially every day if I don't go down Green Meadow to Franklin Mine. From my house, I can see the railroad tracks, and the trains routinely block head lane for more than is allowed under statute of 15 minutes. And sometimes they're good and they'll back up and then they'll move forward and they allow cars to pass. But my concern is watching several times safety vehicles have come up the road. And if the train is blocking, they have no way of knowing, and it's going to add time to getting around, going back down Country Club, up Green Meadow, and onto Franklin Mine. So I just mentioned that for commissioner awareness. I did mention this last year to staff, and I think staff did a nice job sending someone out, but it's continuing to happen. So again, I just highlight that for the commission. So thank you.
Thank you. We appreciate that public comment. Any additional public commenters in the room? Seeing none. Any public commenters online? I'm told there are not. All right. We do not have any changes to the agenda this morning, so we will move forward with our first action item. Action item number 1 is approval of the commission minutes for the week of December 18, 2023. Is there a motion, Commissioner Pinocci? All right, Commissioner Pinocci has made a motion to accept the minutes as written. Is there a second?
I second the motion, Mr. President.
Vice President Fielder has seconded. We have a motion and second. All right, any changes, revisions, edits to the minutes as drafted? Seeing none, all those in favor of Commissioner Pinocci's motion to adopt the commission minutes for the week of December 18, 2023 as drafted, signify by saying aye.
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 All those opposed signify by saying no. Seeing no opposition, motion carries. Minutes are approved. All right, let's move into work session item number 1. This is Docket 2023.07.064. This is Montana Roll-Offs LLC. We're here on the application for Class D Certificate of Public Convenience and Necessity. We're here to consider the motions for summary judgment that have been filed by Allied Waste Services in North America, doing business as Republic Services and McKinsey Disposal, Inc. And separately, Allied's motion for leave to reply in support of its summary judgment motion. Good morning.
Good morning, President Brown and Commissioners. As an overview, as President Brown stated, there are 3 motions before the Commission today. Staff proposes the draft order, which is before you, to resolve all 3 motions. As an overview, staff first recommends that the Commission deny Allied Waste Services motion to reply to MT Roll-Off's answer regarding the 2 summary judgment motions. Because the reply is included in Allied's motion to reply, and because it's relevant to the standard of law that the Commission should consider when evaluating summary judgment motions. Second, regarding the motions for summary judgment, staff recommends that the Commission deny both summary judgment motions because the standard under law for the Commission to deny MT Roll-Offs a hearing on their Class D application is not met. I'll go into detail a little bit more here. First, regarding the motion to reply, under the Commission's standard procedural rules, usually only a response is permitted within 5 days of filing a motion, and no reply is permitted. In this instance, Allied Waste Services states that MT Roll-Offs in some ways replied regarding summary judgment in another motion that was pending back and forth regarding an extension of time. To the extent that Allied includes the substance of their reply in their actual motion, staff recommends that the Commission grant that argument. The argument is on page 3 of Allied's motion to reply, and they talk about the standard of law that the Commission should evaluate when deciding a summary judgment motion. So we believe that is relevant for the Commission's consideration. As staff recommends that we deny the motions for summary judgment, Allied will not have an actual opportunity to reply, but we're granting the reply, or would recommend that the Commission grant the reply to the extent it's actually included in their motion for reply. Second, regarding the 2 motions for summary judgments. As you may know, the standard for a motion for summary judgment is that there is no genuine issue as to material fact, and that the movement is entitled to judgment as a matter of law. Usually the civil procedure rules are not incorporated in the Commission's decisions, but they have been in the past, and staff would recommend that the Commission look at the Rule 56 Montana Rules of Civil Procedure Standard for summary judgment. The 2 protestants in this matter both submitted motions for summary judgment. The protestants the summary judgments are arguing that MT Roll-Offs is not capable and fit of providing service as a Class D motor carrier in the requested territories, which includes Yellowstone, Carbon, Stillwater, Musselshell, and Golden Valley counties. The protestants say that MT Roll-Offs has not established that with the facts that have been presented so far in the case. However, the standard for the Commission to deny MT Roll-Offs application for Class D status without a hearing is that the Commission may only deny MT Roll-Offs general right to have a hearing if it is shown that the Commission has previously made an investigation and finding regarding the service territory that the proposed service is not needed, and that the applicant has not established any new facts or circumstances that would entitle them to a different finding than what was previously found. Neither motions for summary judgment point to any previous Commission investigation or finding regarding the proposed service territory. For that reason, staff recommends that the Commission cannot, under law, grant these motions for summary judgment and should proceed with the hearing. Generally, these Class D motor carrier cases are very fact intensive and not particularly well suited to a summary judgment. If summary judgment were granted here, it would deny MT Roll-Offs the hearing in their Class D matter, which is currently scheduled for February 5th and 7th in Billings. I'd be happy to answer any questions you may have about this matter. Thank you.
Thank you, Ms. Webster.
Mr. President.
Commissioner O'Donnell?
Thank you. I'm confused a little bit. I've read the documents submitted by both of the parties, and protestants make the argument that the applicant is not fit because they do not possess all of the equipment, for instance, and many other things as of right now. And I'm unclear when an applicant gives their application to the commission, do they have to specify their capability of performing all the duties, or is that they seem to point out that this is what is provided at hearing, and I'm not sure when this information is supposed to be provided. Could you help me?
President Brown and Commissioner O'Donnell, the commission has a standard form that most applicants fill out when they are applying for a Class D motor carrier certificate of public convenience and necessity. That form does have a space on it for listing the actual vehicles. Generally, MT roll-offs would have an opportunity at the hearing to present any kind of evidence or testimony and supplement to their application regarding meeting the requirements. Commission staff would recommend, based on the law that we've reviewed, that this application proceed to a hearing to give MT roll-offs that opportunity based on what is stated in their application currently.
So before
Thank you. Well,
before we have any further discussion, Commissioner O'Donnell, let's stay in regular order. So I will move to deny Allied Waste Services motion for summary judgment, as well as move to deny McKinsey Disposal's summary judgment motion. Correspondingly, the motion will encompass a grant of Allied's motion to reply, but only to that extent that those portions of the reply brief are granted that are being used in our draft order in this matter. Is there a second?
I'll second the motion, Mr. President.
All right, Vice President Fielder has seconded, so we have motion and second. Discussion.
Point of question, Mr. President.
Yes, Vice President Fielder.
Was it your intention also that this motion would issue the proposed order drafted by staff? I think that's the third component of the staff recommendation.
Yes, it does.
Okay, thank you.
Commissioner, questions? Commissioner O'Donnell.
Mr. Blissett, thank you. So what my query is this, my misunderstanding is that if somebody is applying for services and their ability to engage in business is depending upon the decision of the commission and its legal challenges, then I wouldn't expect anybody to have spent all the money necessary to get in business unless they were already in business and were expanding, such as L&L Services did in a previous docket item. So I'm just wondering is about protestants' the basis of their motion for summary judgment having to do with the apparent inability at this point of the applicant to perform the services. Are they required to have all the equipment ahead of time, or is it? I would think that the approval, that after the approval, that they would go out purchase all of the equipment and hire all of the people. I'm just not sure which one is required to come first. Can you help me?
So, Ms. Webster, I will caution you as to how you respond to this question to not make any commentary that may impact the merits of a hearing held in this matter. Answer to the extent you can.
Mr. President,
Excuse me,
my question is
Commissioner
solely
O'Donnell, please. So try to answer the question
My-
based on the standards of summary judgment. Thank you.
President Brown and Commissioner O'Donnell, to highlight what I explained previously regarding the standards for a motion for summary of judgment, the second prong to grant a motion for summary of judgment is that the movement is titled to judgment as a matter of law. One portion of Montana statute that applies here are those two prongs that I stated before regarding the commission's previous investigation. If those two prongs are not met, there is no other provision that allows the commission to deny MT roll-offs a hearing. For that reason, commission staff recommends that the commission deny the two motions for summary judgment because they do not meet the standard entitling to them to judgment as a matter of law under the statute. This matter is set to proceed with a hearing, and at the hearing, various standards will be evaluated regarding MT roll-offs, fitness to provide services as a Class D motor carrier. There's a three-part factual inquiry under the statute, which is further evaluated by a four-part inquiry. Those two different inquiries that the commission will evaluate further after the hearing when they have more information presented to them is not particularly relevant to the summary judgment motions before you today, because we're looking at what the protestants are entitled to as a matter of law, which those two prongs under statute regarding previous commission findings and investigations is the prong that they fail. So we're just recommending that the commission deny the motions for summary judgment based on that one standard and are not considering other standards at this time.
Follow up.
Thank you. I guess my question to distill it down would be, was the application complete? You said that there is a part on the form to list all their equipment. What is required? I'm just wondering, was the application complete as to everything that the law requires? Or is just somebody just saying in an application they intend on going in business? And this responds directly to the application for summary judgment. Please.
President Brown and Commissioner O'Donnell, I do not have the actual form in front of me or the statutes regarding the application requirements. I can tell you that staff did review the application and found it to be substantially complete, so we could move forward with the regular procedural process for Class D motor carrier applications.
Thank you, Mr. President. I will support the motion. Thank you.
Additional discussion? Additional discussion? So a question for you, Ms. Webster. I think it might be helpful for public understanding and understanding of the commission to briefly walk through the Class D application process and then how it proceeds to a hearing and the legal standards for the same, which is what I think Commissioner O'Donnell was driving at. So we'll start with the fact that an applicant for a new Class D license files an application with the commission, correct?
That is correct.
All right, move forward from there.
Once the potential motor carrier files their application, The commission invites any protest related to the application and also public comment. Protests typically come from existing motor carriers in the service territory area. There's an opportunity for discovery between the protestants and the applicant. And the matter proceeds to a hearing regarding standards for a Class D motor carrier certificate of public convenience and necessity to be granted. The framework under statute, which the commission would be deciding at a hearing on the Class D motor carrier certificate, are to evaluate whether the motor carrier proposed service would serve a useful public purpose, whether existing carriers are presently serving a public purpose without the new operation of service, whether the new service third, whether the new service can operate without endangering or impairing the operations of existing carriers contrary to public interest. The commission then applies a 4-part standard to decide whether the applicant is fit and able to perform the proposed service. That requires them to show that there is a demonstrated public need for the service. The commission will evaluate whether the existing carriers can and will meet that need. And then finally, the commission will ask whether a grant of the Class D authority will harm operations of the existing carriers contrary to the public interest.
So building off Commissioner O'Donnell's question, so describe what the agency looks at in terms of the completeness of the application.
President Brown, when the commission evaluates the completeness of the application, we're typically looking at what's on the face of the form that is provided, as well as checking off any standards that are required by statute or administrative rules. We're generally looking for the application to be substantially complete as to meeting the requirements that are listed in the form application.
So generally, Ms. Webster, that you would describe what the commission review is of the completeness of the application as a ministerial act, in essence?
President Brown, that is correct. It's reviewed by regulatory staff, and we're usually just reviewing it for substantial completeness.
Okay, and once the commission determines that the application is substantially complete, then it's my understanding that, as you stated, there would be a period where protestants can protest, correct? File a protest with the commission, and then there's a period of discovery, correct?
Correct.
All right, so we have completed the discovery period in this matter or not?
President Brown, the discovery in this, I believe, is substantially complete. I would have to double check the administrative record, but there has been a set of data requests and responses back and forth between applicant and protestants.
All right, and so what you've described to us, as I understand, is that under the summary judgment standard, which there is discussion in this order about what standard we actually apply, whether it's the civil rules of civil procedures, Rule 56 standard, or modified standard, if you will. But setting that aside, commission can only, as I understand it, the commission can only grant summary judgment at this point of the proceedings if a 2-part test is met, correct?
President Brown, that's correct.
Okay, and that 2-part test is the commission's records must demonstrate that the route or territory sought to be served by the applicant, in this case, Montana Roll-Offs, has, quote, previously been made the basis of a public investigation and finding by the commission that public convenience and necessity do not require the proposed motor service, carrier service, correct?
Correct.
Okay, and so if we issue the draft order in this matter, the commission is determining that neither Allied nor McKinsey, the parties moving for summary judges in this matter, has proven as a matter of law at this point in the proceedings that the service territory has previously been made the basis of a public investigation and finding by the commission that public convenience and necessity do not require the roll-off service, correct?
President Brown, that's correct. Neither motion for summary judgment points to a commission finding or investigation that meets that standard.
Okay, and I think back to Commissioner O'Donnell's question, we are not the application itself that's filed for the license is not the basis of proof, if you will, for making a determination as to the summary judgment, correct?
President Brown, that is correct.
So the applicant doesn't have to prove on the face of the application that the need for public convenience and necessity is met on the face of the application, correct?
President Brown, that is correct. I'd just add that the applicant has an opportunity through discovery and also what they present at the hearing to meet that standard.
Okay. And I think you would agree with me, although you haven't been on the commission as long as I have, and I certainly haven't been on the commission as long as some commissioners here, that these Class D application proceedings are not really conducive to summary judgment or proceedings, correct?
President Brown, that is correct. The applicant and the protestant here have significant dispute regarding the material facts to this case.
Okay. I'll speak in favor of my own motion. It's clear to me, having read the briefing in this matter and considered the various motions, that there are still outstanding material facts that need to be developed and elucidated in this matter, and that the movements for summary judgment have not established as a matter of law that they are entitled to relief requested in their summary judgment motions. As to the more confusing matter in my mind is the question of the motion for leave to reply filed by Allied. Ms. Webster, it's my understanding that the scheduling order in this matter did not authorize reply briefs. Is that correct?
President Brown, that is correct.
But Allied has filed a reply brief with the commission, correct?
President Brown, Allied included the substance of what they would reply in their motion for leave to file reply. So yes, they did include a reply within the motion.
All right, was that objected to?
President Brown, none of the parties objected to Allied's motion for leave to file reply.
Okay, and it's my understanding from what you've presented today and what we're finding in the draft order is that even though Allied was not authorized under a scheduling order to file a reply, that we are going to consider portions of the reply brief that have been fine to the extent that we, as a commission, determined that it was useful for creating and disposing of the summary judgment motion, correct?
President Brown, that is correct.
Okay, thank you for that clarification. Additional discussion? Additional discussion? Seeing none? All those in favor of my motion to deny the summary judgment motions of Allied. I'm not sure if that's Commissioner O'Donnell or check, but someone needs to mute. Thank you, Patricia. All right, back to the motion. All those in favor of my motion to deny the motions for summary judgment filed by Allied Waste Services and McKinsey Disposal, and correspondingly to grant Allied's motion for leave to reply in support of its summary judgment motion, but only to the extent that the argument that we have considered for purposes of disposing of these motions for summary judgment, and to issue the proposed order with clerical edits signify by saying aye.
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 All those opposed signify by saying no. Motion carries 5-0. Thank you, Ms. Webster. We will move to work session item number 2. This is docket 2023.12.101. This is TriStar Holloway, otherwise known as TriStar. This is the application for Class D temporary operating authority. We're here to consider granting TriStar temporary operating authority before giving public notice of the application. Ms. Webster.
Good morning again, President Brown and commissioners. As an overview, TriStar is requesting to transport general household solid waste and light construction material using small trailers on wheels within a 45-mile radius of Belgrade, Montana, and Gallatin and Park counties. TriStar has submitted a permanent application for a certificate of public convenience and necessity, and subsequently submitted an application for temporary operating authority. Under the commission's administrative rules, there's a special provision that allows the commission to grant temporary operating authority before public notice of the temporary operating authority application for up to 30 days. In order for the commission to grant temporary operating authority, the applicant must show that there is an immediate and urgent need for the proposed service, as well as that there is no carrier capable of providing that service. Staff recommends that the commission decline to exercise its discretionary authority to grant TriStar temporary operating authority before public notice because its application does not contain sufficient facts to meet the requirements for temporary operating authority under statute. This is because on the face of TriStar's application, there's nothing indicating that the existing certified carriers in Gallatin and Park counties are not capable of performing the proposed service. Specifically, the application does not show that Allied Waste Services of North America was contacted, nor Mountain Wind Construction, which operates in Park County. There's a requirement the application is submitted along with shipper affidavits establishing a need. The affidavits that are attached do not, one, from an actual potential customer of TriStar, does not contact any certified carriers, and the other affidavit that is included with the application contacts L&L Waste Services, but not the other carriers in this matter. Normally, with a temporary operating authority application, this matter will be noticed for an opportunity for public comment and on protest. If the commission goes forward with the draft notice of commission action, that is what staff will do to notice this application and will encourage any potential protestants to provide information on what services they can and cannot provide. The commission will still have an opportunity shortly to make a final decision on the temporary operating authority application once there has been an opportunity for public notice. I'd be happy to answer any questions. Thank you.
All right. Thank you, Ms. Webster. I will move to I guess the best way to put it would be to decline to have the commission author to exercise its discretionary authority to grant temporary operating authority to TriStar before public notice of its application is given, and in turn issue the proposed notice of commission action with appropriate clerical edits. Is there a second? Commissioner Pinocci is seconded. Thank you. Discussion, questions?
Mr. President.
Commissioner O'Donnell.
Thank you. In reading the documents submitted, questions arose with me. It seems like TriStar is providing a service that, from my knowledge, none of the other companies that you mentioned, this basic on my information from previous cases, provide the same type of service, which is basically a small trailer pulled behind another vehicle to take small amounts of household garbage, or, as I said, light construction on the whole thing. It struck me that none of the other carriers provide any such service. They have roll-off dumpsters, or they have garbage trucks. But I'm not familiar with anybody else who provides the same service. So my point is that it seems like that the TriStar would be performing a service that the other existing carriers are not capable of doing. Certainly, they have not offered this service before, and I'm just thinking that they might be providing a need for the market that is unmatched by any other carrier. I would like to find out if I'm correct on this feeling.
Ms. Webster?
President Brown and Commissioner O'Donnell, that is a good question. After looking through the temporary operating authority application, the requirements for granting a temporary operating authority application require that the supporting affidavits lists the names and addresses of existing carriers who have either failed or refused to provide the service and the reasons given for any such failure or refusal. Here, the affidavits supporting the temporary operating authority application do not have any information about Allied Waste Services of North America or Mountain Wind Construction. We don't have any information in this particular docket regarding the size of dumpsters that Allied Waste provides or Mountain Wind Construction, as neither carrier was contacted to provide the requested service. The applicant does state that no one else they've found can provide the proposed service, but our administrative rule requirements require that to be supported with a specific affidavit saying something along the lines of, I contacted these 3 specific certified carriers in the area and they refused to provide the service or only had a certain size of dumpster available. Because that information is not in the application, we don't have the requirement met that no carrier services is capable of meeting this need based on the face of the temporary operating application.
Follow up?
Mr. President, thank you. Yeah, I appreciate the answer, and I can certainly see that there are administrative rules to follow, and I don't have a problem with that at all. I would just hate to see the entrepreneurial initiative of a small carrier to fill this void to be quashed on that thing. But I see what you mean is that the application was not sufficient in this regard. A mere statement that none of the other existing carriers are willing to do this is not specific enough to match our administrative rules. You know, I guess what I have to say is that I'm applauding somebody who was willing to do short hauls like this, small loads, to fill a void that seems to exist. But I certainly understand from the point of view of the application. It seems to me that by saying none of the others carriers can fulfill this, that presupposes that the applicant contacted these carriers without specifying that they were contacted. And I don't know. I'm inclined to not support the motion to allow the TriStar to perform this service, and it seems to me that it is a need that completely unmet by any of the existing carriers, Mr. President.
Thank you, Commissioner O'Donnell. Did you want to respond to that anyway, or just wave off?
President Brown, I could.
Pardon me, I'm sorry? Oh,
Sorry, go ahead.
President Brown and Commissioner O'Donnell, as a brief response to Commissioner O'Donnell's comment, there's still going to be an opportunity for the commission to make a final decision on the temporary operating authority application. Staff, if this is granted or if it's not, whatever that happens, the next step in this process for the temporary operating authority application is to notice it for the public, to invite any comments and comments from the protesters as well. If there are no protesters, or if there are protesters, that will influence staff's recommended final decision for the commission on the temporary operating authority application.
Additional discussion?
Thank you. Mr. President, thank you for that. I appreciate the explanation that this does not exhaust the ability of the commission to grant a temporary operating authority in this matter. Thank you.
Additional discussion? Can you mute yourself, Commissioner O'Donnell? Mute.
Mr. President,
Okay, I think I heard Commissioner Bukacek.
if I may, I greatly appreciate the discussion today between you and Ms. Webster regarding the Class D carrier issue, and the clarification I think is a great benefit to the public understanding regarding our jurisdiction related to the Class D carrier application process and our analysis of it. And I will be a yes vote.
Thank you, Commissioner Bukacek. Additional discussion? Additional discussion? Ms. Webster, I'd just like to commend you on your response to Commissioner O'Donnell. I think you've elucidated what the issue is at present before the commission is whether or not we issue a temporary operating authority without notice to existing carriers. That is a discretionary call on behalf of the commission, as you noted under commission rule. However, as I think you stated, is that the commission should not exercise its temporary authority because the affidavits, which is the legal proof we have before us, don't support doing so. As you stated, we are not quashing, as Commissioner O'Donnell used the term, anybody's rights to proceed to determine whether or not they should be licensed. We are merely determining whether that authority should be exercised without notice. And I don't believe that standard has been met at this time. It's not a judgment on the merits of the case. It's a merits on the proceeding before us. Additional discussion?
Mr. President,
Vice President Fielder.
I appreciate the discussion here and your succinct summation of the real issue at hand, and I agree with that. So I will be supporting the motion. Thank you.
Thank you, Vice President Fielder. Additional discussion? Additional discussion? Seeing none, all those in favor of my motion to deny grant of temporary operating authority at this time signify by saying aye. Aye.
Aye.
Aye.
Commissioner O'Donnell? Can you unmute Commissioner O'Donnell? There.
Mr. President,
Yes.
I will. My intention is to vote no. I was waiting for you to call for the no's.
Oh, I'm sorry. I got confused there, Commissioner O'Donnell. I thought you said you were going to support it. All right. All those in opposition signify by saying no.
No.
Okay. Registering one nay vote, motion carries 4-1 with Commissioner O'Donnell dissenting. Ms. Webster, excellent work. Thank you. Work session item number 3, docket 2023.10090, Montana Dakota Utilities. This will be MDU rate 93 tariff update. We're here to consider a commission draft notice of additional issues in this matter. Mr. Poco.
Good morning, President Brown, commissioners. As you mentioned, President Brown, we are here to consider additional issues in Montana Dakota Utilities Rate 93 tariff under docket 2023.10.090. This case concerns MDU's proposed standard rate tariff for purchases of energy and capacity from small qualifying facilities under PURPA. MDU's Rate 93 tariff details standard purchase rates for QFs that produce 3 megawatts or less in nameplate capacity. MDU updates its energy purchase rates in Rate 93 annually based on forecasted market prices from MISO. The standards set forth in Montana Administrative Rule 38.5.1905 require, among other things, that purchases made to QF shall not exceed the utilities avoided costs, and furthermore, that for purchases subject to an established legally enforceable obligation, the avoided cost of capacity will be calculated at the time the legally enforceable obligation was formed, and the avoided cost of energy will be calculated at the time of delivery of the facility's energy. Based on the administrative record to date, it appears MDU's proposed rates for energy purchases subject to an LEO would not be calculated at the time of delivery of a qualifying facility's energy. Although the Montana Consumer Council is a party in this proceeding, no discovery was conducted on their part. Neither MCC nor MDU have addressed the question of whether MDU's proposed tariff complies with the commission rule that requires energy rates to be calculated at the time of delivery. Likewise, neither of the parties have addressed whether there is good cause to waive the application of the commission's on-time of delivery rates for energy purchases. When issues are not adequately addressed by a party in a proceeding, the commission must initially identify those issues and provide the parties an opportunity to address the identified issues. Accordingly, staff recommends that the commission direct the parties to address the following two issues. One, are the energy rates in MDU's proposed rate 93 tariff consistent with Montana Administrative Rule 38.5.1905, subset 2? And 2, is there good cause to waive the application of the rule in this case? Commission staff would convene a status conference with the parties to discuss procedural deadlines for addressing these additional issues and publish an amended procedural order to reflect any necessary procedural deadlines that result from the status conference. Before you is a draft notice of additional issues. Staff recommends that the commission adopt the proposed notice as written with the permission for staff to include any non-substantive changes that are deemed necessary. If you have any questions, please let me know. Thank you.
Mr. Poco, anything to add at this point in time?
Nothing to add at this point in time, President Brown.
All right. Do we have a motion? Commissioner Finochi?
Thank you, Mr. President. I make a motion to support staff recommendations.
All right. Is there a second?
Second.
Commissioner O'Donnell has second. So we have motion and second. Discussions? Questions?
Mr. President.
Commissioner O'Donnell?
Thank you. Looking at paragraph 7 of the draft order on this, it says, upon review of the record, it appears MDU's proposed rates for energy purchases subject to an LEO would not be calculated at the time of delivery of the QF's energy. Neither MDU nor MCC have addressed the question of whether MDU's proposed tariff complies with the commission that requires energy rates to be calculated at the time of delivery. Well, here's my question. At the time of delivery, and MDU has said that their standard for what they would use would be the MISO auction rate that was available at the time. And it would seem to me that what MDU is saying is that they're in compliance with PURPA, that their obligation to not exceed the cost that would cost them produce the electricity or to purchase it on the open market. They're using MISO price as a proxy for that, and it would seem to me that satisfies that particular point. Am I reading that correctly? Can someone help me with that?
So President Brown, Commissioner O'Donnell, that is correct that the MISO market is used to forecast their avoided cost rates so that the rates will not exceed their avoided costs. However, this is done on an annual basis. So at the time of delivery, we have yet to really clarify what at the time of delivery means. If that means on an hourly basis, at the very second at the time of delivery, or if an annually forecasted rate is sufficient.
Thank you. As I understand, the MISO rate is that it is set at an annual auction, or, well, no, they've moved that. Apparently, they've moved it to a seasonal allocation rather than just an annual thing. I'm not sure about the small facility, the 3 megawatt and less on that, but I believe they've gone to that. So that would, it seems to me that rate would change on more than an annual basis, if I'm not mistaken. But I think the purpose of this motion is just to add additional questions. It's not deciding the matter at this time. So I just wanted to raise those issues, clarify my understanding, and I will support the motion. Thank you.
Thank you, Commissioner O'Donnell. Mr. Poco, did you want to address that? I think Commissioner O'Donnell addressed his own question right there at the end, but go ahead.
President Brown, Commissioner O'Donnell, just briefly to reiterate on Alexandra's presentation, the MISO market may provide more than annual updates. And I'm in fact, no, it does provide more than annual updates on its pricing. I'm not sure if they have a day ahead market or what type of market exactly. However, because MDU is setting its rates in this docket for an entire year, it is of staff's belief that it doesn't currently comply with the rules because there's nothing on the record demonstrating whether the proposed rate 93 is consistent with the commission's rules, and there's no request to waive that rule. Staff recommends the additional process procedures.
Additional discussion?
Thank you.
Additional discussion? Seeing none, all those in favor of Commissioner Pinocchi's motion signify by saying aye.
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 All those opposed signify by saying no. Seeing no opposition, motion carries 5-0. All right, thank you. Excellent work. All right, let's move to work session item number 4. This is docket 2022.07.073. This is Colstrip Energy Limited Partnership, otherwise known as KELP. KELP's petition to set terms and conditions for a qualifying small power production facility. We're here to consider Northwestern Energy's motion for extension of time to file a compliance purchase power agreement. Mr. Poco.
President Brown, commissioners, as President Brown mentioned, this concerns KELP's QF docket. Recently, on December 12th, the commission ordered its order on reconsideration in this docket. In that order on reconsideration, the commission ordered Northwestern to submit a compliance filing by December 27th. Subsequently, Northwestern filed the motion for extension of time to file a compliance power purchase agreement, which is what we are considering today, requesting that the commission extend the deadline to file its compliance purchase power agreement, or PPA, from December 27th, 2023 to January 26th, 2024. KELP filed a reply to Northwestern Energy's motion. KELP opposed Northwestern Energy's motion and proposed an alternative timeline for Northwestern to file its compliance PPA. Turning to Northwestern's motion first, Northwestern argued that several circumstances established good cause, primarily that the deadline was currently set right around the holiday season and due to current staff workload. Concerning Northwestern's request, staff did not find good cause existed to extend the deadline to January 26th because the holiday season has now passed and because there was already a PPA filed on reconsideration from Northwestern, and in this docket, the commission required Northwestern to use its own base PPA. So good cause did not exist to extend that deadline nearly a month. KELP proposed an alternative in its reply. KELP proposed the commission set a January 12th deadline to send the PPA to KELP itself, a January 19th deadline to file with the commission, the compliance PPA, and January 26th for arguments essentially about the PPA to be filed with the commission. Staff in the draft order before you today did not believe that that process is necessary. This case is fully concluded at this point, and staff has an informal compliance procedure that will allow for a quicker disposition of the issues with the compliance PPA that Northwestern has to file. However, because we are considering this today, January 9th, staff recommends to extend the deadline to January 19th for Northwestern to file the compliance PPA. That also comports with KELP's date that it requested Northwestern to file the compliance PPA with the commission. Staff recommends approving the draft order and allowing for any substantive edits required for, or non-substantive edits required for clarity. I'm open for questions. Thank you.
Just a clarification before we take a motion on this. So to the, Mr. Pogo, to the last point that you were making, the proposed draft order does have January 19th date. So what you're representing to the commission right now is the draft order is correct per your recommendation?
President Brown, commissioners, that is correct. Staff recommends the January 19th date extension because the commission is considering it today, and that will allow parties, Northwestern, an extra 10 days from this point to finalize its compliance PPA. And because KELP agreed that that date is sufficient.
Okay, that's helpful. Thank you. Is there a motion? Commissioner Pannocci.
Thank you, Mr. President. I make a motion to support staff recommendations to move the extension date to January 19th.
Okay. Is there a second?
A second.
That was Commissioner Bukacek. We have motion and second discussion.
Mr. President,
Commissioner O'Donnell.
thank you. Mr. Polko, what is the essential difference that is be gained by shortening the period of time that Northwestern has requested of the 26th to the 19th? We're talking about 7 days. Is there anything really at issue right here as to why we wouldn't give either parties the extended period of time that they have requested?
President Brown, Commissioner O'Donnell. In this instance, Northwestern has the obligation to show that good cause does exist to extend the deadline. That's in the commission's rules. Because Northwestern has not carried that burden based on the facts at issue here, staff recommends that the commission shorten the deadline or shorten the extension request because Northwestern was already supposed to have filed this on December 27th, 2023. Furthermore, this docket has gone on since nearly July of 2022. There's the current contract between KELP and Northwestern ends in June of this year, and that was a consideration that was discussed heavily during the entirety of this proceeding. So at this point, staff's recommendation is to shorten the timeline even by a week in order to try and provide the most expeditious relief as possible in this docket, considering those deadlines.
Follow up?
Yeah, thank you. I'm thinking of a line from the Merchant of Venice that the quality of mercy is not strained by 7 days. I don't know why that is. I think if Northwestern has said that they requested until the 26th because of administrative workload on their part, that strikes me as being sufficiently good cause for asking for that. I just don't know why we're pressing the issue. It seems to me that the posture of this commission for all the years that I've been on it is to be acquiescent to please by any party for additional period of time. So in the matter of 7 days, and I understand what you're saying, that this has been dragging on for a very, very long time. I certainly understand that. I don't see that anything is gained for the process for any parties by shortening the period of time by 7 days. But I could see that there is a possibility that the process might be enhanced by Northwestern having the period of time that they asked for because of administrative burdens. So I will be not supporting the motion. Thank you.
Mr. Polko.
President Brown, Commissioner O'Donnell, briefly, motions for extension of time are not routinely opposed, and that is more than likely the reason that it is routinely granted. In this instance, KELP did oppose Northwestern's request for extension of time, and the commission or staff in the draft order discussed the good cause standard that is required to evaluate the motion for extension for time. Again, normally these are uncontested and are generally granted.
Mr. President.
Hold on, Vice President Fielder. Commissioner O'Donnell, any follow up on that?
No, thank you, Mr. President.
Vice President Fielder.
Mr. President, I concur with staff recommendation here, primarily for the fact that KELP is a company that is under some very major deadlines coming up July 1, and those come fast, and they need as much time as possible to ensure they've got their personnel and their equipment and their supplies all in place so that they can continue to provide reliable coal-fueled electricity on or after July 1st, 2024. So I'm going to concur with the staff, the motion here, because I don't think that this commission should facilitate further delay in this matter. I think we need to allow this company to do what it needs to do to move forward to provide that reliable energy for the people of Montana. Thank you, Mr. President.
Additional discussion? Additional discussion? I'll weigh in briefly on this. In response to Commissioner O'Donnell's literary reference, I will rebut by saying, Commissioner O'Donnell, I feel like your argument comes right out of Don Quixote, where you're tilting at windmills. So I would just remind my colleagues that the commission ordered Northwestern Energy to submit a compliance filing by December 27, 2023. That's the commission order at present. So, Mr. Polko, have they submitted that at this point in time?
President Brown, commissioners, they have submitted some of the compliance filings. However, they have not submitted the compliance PPA, which was addressed, I believe, in paragraph 60 of the order on reconsideration.
Right now, Northwestern Energy is essentially in non-compliance with our order, correct?
President Brown, commissioners, that is correct. Particularly, the commission was unable. The request for extension of time was filed prior to the deadline. However, due to, again, scheduling in the holidays, the commission has not been able to consider those motions. But based on the plain language of the order, President Brown, you are correct.
All right, and you stated correctly that generally extensions of time are not routinely granted, correct?
President Brown, commissioners, I stated that requests for extension of time are usually granted because they are uncontested or agreed to by the parties.
Okay. Then I also think you averred that KELP has indicated that it is comfortable or has represented that some extension of time is acceptable here.
President Brown, commissioners, that is correct.
So if we issue this order, essentially we're splitting the difference, correct, between the parties such that the interests of both parties are protected here, correct?
President Brown, commissioners, that's correct.
All right. So I'm going to support Commissioner Pinocchi's motion. All right. Additional discussion? All right. Seeing none. All those in favor of Commissioner Pinocchi's motion to issue the draft order on motion for extension of time as the final order of the agency and to allow staff to make clerical edits, signify by saying aye.
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 All those opposed signify by saying no.
No,
Commissioner O'Donnell is being a contrarian today, everybody. Vote is 4-1. Motion passes with Commissioner O'Donnell opposing. Thank you, Mr. Poco. Excellent work.
Mr. President,
Yes, Commissioner O'Donnell.
Mr. President. Yeah, may I point out that it's a matter of perspective on who's being contrarian.
Do it. All
Should we
right.
take a vote?
We shall not, but we do have a request from our staff that we take a break right now. 10:35 to give staff about 10 minutes to set up the next two presentations. So we are inclined to grant that. So the time is now 10:35 a.m. We will go into recess until 10:45 to allow staff to prepare for the next two presentations. All right, Vice President Field, are you back on?
Yes, sir, I am. Thank you.
Commissioner O'Donnell?
Yes, sir.
Bukacek?
Yes, sir.
Time is now 10:45 a.m. We will back on the record, reconvene our business meeting. Where we had left off was with work session item number 5. We are here to receive an update on our annual pipeline safety program. And to hear about the good works that is done by the staff of the same. Sam, Joel, who's going to kick off? Joel, good morning.
Mr. President. Yeah, we will give you a rundown of activities for the pipeline group for 2023. As your commission is aware, at the end of 2023, we did lose John, so we'll be in the process of hiring someone new, which may take a little bit of time, but through the year of 2023, John was still here, so this reflects numbers, including what he had done. This is just a map of some of the areas that we had gone to throughout the state with the triangles identifying inspections that we'd done. As you can see, the largest triangle, we had a lot of work we did this year in Shelby. So Shelby, we did six different inspections in Shelby this year, just because that's the way it was slated for them to get done. We did 75 total inspections completed. We got 179 inspection days. Through the process, we wrote 4 violations. We had 8 violations carried over from the previous year. Now, usually we'll have carryovers because they're usually violations that are written towards the end of the previous year and they'll carry into the next year. And now those 12 violations, 11 of those violations were corrected in 2023, and we're currently still working on one of the violations to be corrected. I think, my take is that, that we're doing a pretty good job. We're not finding as many violations when we go out there. The utilities are doing a pretty good job of maintaining their stuff. So we're just not finding it, which is a good thing. Some of the major accomplishments for 2023, we retired 3 master meter operators. We had 4 master meter operators left. We'll talk a little bit about that in the next slide. We've had those for years and years. And the whole time that I've been here, we started with them. There was roughly like 140 of them to begin with. Over the last 25 years, we've been trying to whittle them down. We had them down to 4. We finally, with a lot of hard work and work with Northwestern, we were able to get those retired. 3 of the 4 retired, with number 4 going to take place this coming summer. We discovered 1 new master meter operator. That was kind of ironic. It came about. It's up in the Glacier area. We found it when one of our gas suppliers, Trough Petroleum, who was one of our licensed gas suppliers, retired and went out of business. Through that process, we found out that also included a master meter operator, but that they were working with Northwestern also, and that one should be going away in this summer too. So that will be good. We responded, not necessarily responded, but we worked on 2 different non-jurisdictional events. There was a event in West Yellowstone. Was it last February, Sam? February timeframe, where there was a motel that exploded. It was closed for the winter, but luckily there was no injuries. But it was not jurisdictional of this commission. It was on the propane system and not on the LNG system in West Yellowstone. Then, of course, one of the biggest things this commission did back in October is we issued the waiver for Highland Partners to continue to operate their Bakken residue line out in the eastern part of the state, which was a pipeline that was joined, other than by welding, it was joined by a process using Zaplock joining. This is what's considered a master meter. A master meter is basically where a utility will set a meter, and their jurisdiction ends at the beginning of the meter, and then the outlet swivel of the meter, the owner of the property takes jurisdiction. There may be various buildings downstream with underground piping. Not a good situation because there's nobody looking at that piping. Northwestern has no responsibility to it. This is a meter. This is one that was just retired in Butte at Eddie's Motel. That meter is gone and the system's completely redone with new piping and new meters set at each building. So now that system is just part of the Northwestern system. We'll get leak surveyed. We'll get all the maintenance taken care of, just as any other thing on the Northwestern system. Is absolutely the best outcome. And that's what's going to happen with those four. The three of them are already done. There was the one in Butte. There was two of them in Kalispell that are completed. There's one left, which is a housing authority, which is a bigger project in Anaconda that will be completed this coming summer. Like I say, they're more problematic because they're difficult to deal with. When we go in to deal with them, they could have an owner that was there today and 6 months later it's a different owner. They may not be aware of it. It's just not a safe, good situation. So the situation that we did with working with Northwestern to get rid of these was absolutely the best outcome. So it's nothing left for the owner of the trailer park or the owner of the motel to have to deal with. The Highland Partners joining waiver application, this was kind of a big deal. We worked on this for probably about 3 years, getting it together, working with PHMSA. Finally, before the commission was able to issue its order back in October. It's an 8-inch steel pipeline that runs about 9 miles out in eastern Montana. It runs from a gas processing plant, dumps natural gas into the WBI line. It's got an allowable operating pressure of 1,440, and it delivers gas into the WBI system at 400 PSI, joined with a zap lock process, which was a process that they don't weld the pipe together. It's kind of like a bell and lock and bell process. So under that process, when that pipeline was built back in 2010, there was a interpretation that came out by PHMSA back in the 70s that basically said that utility or gas operators could join pipe with zap lock. And so we operated under that. And so in 2010, when they built this pipeline, they built it with zap lock piping. But 2016, PHMSA reversed course and said, you can't join pipe. The only way you can join a gas transmission line is to weld it. Can't be joined by this process. It's not a approved process. So we had to go into the waiver process. We worked, like I said, we worked three years on this to get it right, because this isn't the only pipeline operating in the United States under the zap lock process. There's many more, and there was a lot of eyes on us because this is the first waiver that was granted. So we wanted to make sure we had everything in order that we needed, and the waiver was finally issued in October of this year. So they are operating under that waiver, currently under the conditions of that waiver. I just explained the zap lock. This is our old database. This is the access database that we use to track inspections, where we enter in our information. We track our required days, our required inspections. We're in the process of melding this into the READY system. We're not quite ready with the READY system. There's still some things that need to be done before we can cut over to the READY system, but that's just the statistics that we keep. Of that, of the amount of person days that we get in a year, we're required to get 20% of those as considered construction field days. So we will travel all over the state to the various utilities while they're in the field, whether they're putting a main in, a transmission line in, a service line in, and be there while they're doing that to get 20% of our inspections as construction inspections. These are just some statistics. As you can see, from 2010 to 2022, the amount of pipe that's been put in the ground in Montana with services mains. The chart down below just kind of shows that the decrease in the steel and the increase in plastic, which is good, means that a lot of the steel is getting replaced. This is just some transmission statistics. We have 4 transmission operators. MDU does have a little bit of transmission outside of Billings, about 2 miles. Obviously, our biggest transmission operator is Northwestern Energy between their main transmission line and their Havre pipeline. And then the Highland Partner pipeline that we had just talked about is 9 miles of transmission. So we have roughly about 2,270 miles of transmission in Montana, with the vast majority of being on the Northwestern system. We do look at underground gas storage. We started this in 2020. There's 3 gas storage fields. They all belong to Northwestern. There's the Cobb, Dry Creek, Box Elder. We do that storage program kind of as a separate program in addition to what we do. And we do, we inspect that every year for records, and then we visit one field per year. So we do another 3-year rotation. So we see one this year, one next year, and rotate back. That's how we do the inspections of the storage units. So we're fairly large storage field. Outlook for 2024, we're required to get 171 days, but we'll shoot for 185. We always try to shoot for 185. That number is determined by various factors. We use a formula to determine that. Hire a new inspector, obviously. That's a priority. Integrate the 2 databases so we can just rely on the Ready system to track our information. Training, I got 1 training class I'm going to have to do. Sam's got 3 left, and then the new hire is going to have to get the 7 core classes. They'll be required to go through probably about 22 or 23 classes before they're completely trained to do it. Continue to work with small operators. We have smaller operators that take quite a bit of time, and continue to make sure that those 2 M master meters are taken over and put on the Northwestern system. Also in February of 2024, we're hosting a operator seminar. That's where we bring in utility folks from around the state, and we bring people from Oklahoma City and from around PHMSA, put a seminar on, and they learn about the new regulations that are coming out. Some of the stuff that's out there, they like coming to these. They're good. We get good information to them. And there's another one. We try to do them on a 2-year rotation.
So where were the, excuse me, where will the seminar be?
It's going to be held. Anybody would be welcome to go to that. It's going to be held at the Grand Tree, Best Western Grand Tree in Helena, February 6th and 7th.
And how many folks do you attend that?
We expect usually probably 60 to 75 from around the state, utility people to come. This year, we're going to it's going to be a little bit different. There's a lot of new faces in the utility world, a lot of young faces in the field. So we're going to try to go back, step it back, and kind of go back to the beginning of the basics and try to give some of these people some of the basics of why they're doing what they're doing out there in the field and why what we're doing. And some cover some of the newer stuff that has come out. So that was a request by the utilities themselves. And of course, another big thing we'll do this year, we'll go out on the Highland Partners pipeline, and we'll have to do a full inspection to make sure that they're compliant with the 11 conditions of the waiver that the commission issued back in October. That'll be a high priority, which I don't think it's going to be an issue. They've already been doing 3 or 4 of those conditions prior to that, so that should not be a problem. Any questions?
Commissioner Pinocci?
Thank you, Mr. President. So Sleepy Hollow kind of walks off the job. And I can't thank Northwest Energy enough for picking up the ball and supplying service. Do you feel that we need to do some inspections there based on what's happened? Maybe we have done some inspections there. There were some things that had happened where service was kind of delayed during the transformation to go to Northwest Energy. A building was open that was a pump house. How do you guys feel about that?
Part of that, Commissioner Pinocci, Mr. President, when we do the inspection of the Lewistown District of Northwestern Energy, Sleepy Hollow automatically becomes part of that. So we will look at that. We will look at the records associated with Sleepy Hollow. We will do field inspections associated with Sleepy Hollow specifically just because of Sleepy Hollow. But yes, to answer your question, yes, we will go look at that.
So we're thinking that we'll get some inspections done in 2024 there so I can feel comfortable. I'm hoping there's no problems there, but being that there was that lax, that would be a place I'd like us to focus.
No, that was a very good outcome. Most definitely. That system itself in the beginning was not bad, but once now that Northwestern Energy has it under their control and maintenance, it just made it a better system.
My next question is, are there any of these master meters in my district that you can think of?
Gone. They're all gone. We, working over the years, all the ones left, there was a couple of them in Great Falls that we worked, and they've been gone for probably 7 or 8 years.
Yeah.
So the
None
only
in my
way,
district then.
yeah, the only way is, once in a while we might stumble upon one where we find one of these things operating that we don't know about, or somebody might call us and say, hey, this, or a utility might come back and say, hey, this is that. But we've done a pretty good job over the years of just identifying these, and we keep, working with Northwestern or Energy West or MDU and saying, hey, if you see any of these things in the field, let us know. And they have a pretty good idea. And so they identified them all in the very beginning. There was quite a few in your district around the Great Falls area that were Energy West in the beginning just went in and redid them. So they are not gone.
Well, if there is one in my district, if you ever find one, let me know. I can go talk to somebody. So the Zaplock was approved and now we don't use it in Montana. Is that correct?
It was approved. Let me step that back. In the regulations, they never really did approve it. It was very vague in the regulations as to whether it was an approved joining method. When we go look at how somebody's going to join a pipe, there's a section of code that defines what they can use to join pipe, specifically welding. But it never specifically said you couldn't use Zaplock pipe. So there's this interpretation that PHMSA lawyers issue quite a bit of the time. Somebody will ask for an interpretation of code and they'll issue this. Back in the 1970s, they issued this interpretation and said, yeah, we think Zaplock pipe is an approved method. So we operated on that interpretation all the way till 2016. What happened in 2016 is that they determined that some of the other things outside of the Zaplock joining process didn't meet the requirements. So the whole process didn't meet it. So we'd already had, and there was some around the country that had built it under that old interpretation. It built pipelines that were operating with the Zaplock joining that, as of 2016, with this new interpretation, could not do it. So the best way for them to do it was to give them a waiver away from the section of code that wouldn't allow them to do it. And that's exactly what this commission did.
We've never had a failure with a
No,
Zaplock in Montana, though. So I think that's important to mention because that concern comes up. So it's good to say we have not had a failure.
We've not,
My knowledge, we haven't.
no, there's never been a failure. There's never been a leak. The closest thing that came is that on inspection one time that one of the joints had pulled out a little bit, but it and pulled out enough to cause an issue. No, it's not. And now under the conditions of the waiver, they specifically have to leak survey on a quite frequent basis. And there's more conditions on that to make sure that none of that will happen. So actually, I mean, they're doing a lot more stringent type inspections on the pipeline than they normally would if it was welded.
So my last question is Hinsdale. We approved MDU to do some extensive work in gas line replacement. I wanted to follow up. Are they replacing all of that pipe? And then shortly after we approved the money to be used, there was an incident in Hinsdale where there was a leak. So the timing was good. Do you think they've completed or
Completely replaced.
They're completely
Yep.
it's done. That's good to
Completely
hear. I
replaced
wanted
the
to follow
clapping
up.
system. Yep.
All right. And then we've got a town right on the Canadian border, not far from Kalispell, that's completely propane. All right. And I've talked to some individuals up there. There's a gas line in Canada that's just 2 miles away. And this town's getting quite large. Is there any, but talk to the legislature about getting natural gas hooked up to them, but there's nothing the Public Service Commission can really do to encourage that, and just continue to encourage the legislature to consider that with a program with infrastructure money. But I'm hoping they take a look at it because it's a pretty good sized town. All right. Well, thank you, sir.
All right. Good questions, Commissioner Pinocci. Additional questions? I can't see if you're raising your hand, so just weigh in. Additional questions? So back to this conference, Joel. So is this we put this conference on every year, or is it rotating?
No, this one we do as an agency, as a pipeline safety group. We do it every 2 years. We do it in Helena. We provide a space, and we provide the people. We bring the training people from Oklahoma City. I bring people out of Denver. We bring various people in to talk about things that are new, things that are going on within the industry, regulation wise. So the field people themselves, like the guys that are actually working in the field, can see why some of the steps transpires, and we do that on a 2-year rotation.
Very good. Additional questions? Additional questions? Seeing none. Thank you to the both of you for your hard work on behalf of the agency. Certainly, Sam and Joel, I would say a portion of the PSC that flies under the radar oftentimes, but the work you do, as you just explained, is extremely important for the citizens of the state of Montana, to say the least. All right, good job. Thank you. All right, let's call our railroad man up. Mr. Sherwood, you're here to give a update on the railroad program and what you've been up to. You have the floor.
Yeah, good morning, Mr. President, Commissioners. I'll give Patricia just 1 second to pull up the PowerPoint here. All right, looks like we're live. So yeah, just a quick summary of the railroad program update from last year. Start off with some of the more major rail events that we saw in 2023, a couple of derailments, fire, and then a merger. So first one, April 2nd, 2023, westbound train traversing from Laurel to Pasco, Washington, derailed as it entered the east portal of the Paradise Bridge. One hazmat car was involved in this derailment, had 30,000 gallons of liquid petroleum gas. Thankfully, there was no release of the LPG during the derailment. The only hazardous materials that were released in this derailment were approximately 30 to 50 gallons of diesel that MRL, the responsible railroad, worked with third-party contractor to mitigate the diesel that was contaminating the soil. This derailment was caused by a track defect, pre-existing vertical fracture in the rail. If you look at the bottom left picture, you can see in the web in the rail and the head of the rail, kind of on the left-hand side there, the rust is indicative of a pre-existing failure. And then as that crack splits horizontally, you can see it's more shiny. So as the train was traversing it, and the impact of the wheels was hitting the head of the rail, that subsequently caused the rail to fail the remainder of the way and cause that derailment. Next is the Reed Point derailment that occurred in June of last year. Eastbound train traversing the bridge over Yellowstone River derailed. This one had numerous hazardous material cars in the train. Of the 5 cars that went in the river, 3 of them had molten sulfur and asphalt. The railroad is continuing to work in remediating the asphalt in the river. They've worked again with third-party contractors to remedy that situation. Just west of the derailment, 2 cars containing sodium hydrosulfide did derail, but thankfully were not breached, as that would have caused significant issues. This derailment is still under active investigation from the TSB and the FRA, but preliminary evidence is showing catastrophic failure of the middle bridge abutment. I know one thing that they are still waiting to do is get divers to the bottom and see if they can further investigate the original structure of that abutment to come up with the final cause. River Road East Fire. So on August 18th of 23, there was a fire started, burned over 17,000 acres, 15 houses were destroyed. A lawsuit has been filed with the U.S. District Court against both Montana Rail Link and BNSF, as it was BNSF's train on MRL's line, alleging that the fire was started by the railroad. So I'm working with the FRA, pulling data on this case, looking at the locomotives that would have been involved in the train that traversed this track before the fire, as well as repair bills from the cars, etc. December 31st, 2023 was the last day that Montana Rail Link operated as a railroad. They officially terminated their lease of BNSF trackage rights. And so as of January 1st, 2024, BNSF has assumed 977 track miles in Montana. This is significant for us as an agency, as changes the way that Southern Line is regulated. It's now deemed a Class 1 railroad, so there's some changes as far as maintenance of the locomotives, record keeping, air brake requirements, etc. It also removed the only Class 2 railroad in Montana and made BNSF by large the biggest player of railroads in Montana.
Mr. Sherwood, can you define, because I don't understand it, the difference between a Class 1 and Class 2 railroad?
It's determined by Mr. President. That is determined by operating revenue, and so I'm not sure the exact numbers of what stipulates between a Class 1 and Class 2, other than its net operating revenue. I know that Montana Rail Link was a large enough Class 2 that they had gone to Washington D.C. on numerous occasions to petition that threshold to be increased, because they were right on the threshold of becoming a Class 1. And they would have been the smallest Class 1 by a considerable margin. So they didn't want to cross over that threshold, be held to Class 1 standards, and not be able to compete.
So to follow up on my question, and you just answered it, I think right there at the end is that the difference between the Class 1 and Class 2 oftentimes comes down to regulatory oversight or standards. Is that correct?
Mr. President, in part, that is correct, yes. And just a list of some of the defects, the more major defects that we found this year, significant. This is a picture of a overheated wheel bearing that was found in the Silver Bow yard. This is a classification yard that BNSF has, where they receive cars from Union Pacific. So this car was received into the BNSF yard. This was found in September. And as you can see from the grease purging at the bottom of the bearing, that this bearing is failing and obviously going to continue to degrade. This is the same exact defect that was the primary causation of the East Palestine, Ohio derailment. On the next side is a very similar defect. This one is a adapter wear plate. And if you look between the side frame and the top of that adapter bearing wear plate, you can see that wear plate has started to melt out. And this is caused from some defect in that bearing that is causing temperatures to rise and that plastic to melt out. So very similar to the last defect, this potentially could cause the locked axle and a derailment. And
Excuse me, Dan?
Yep.
Is that the light green that you're talking about right there?
Yes, that is correct.
Okay, thank you.
This next defect is kind of unique. It is an MU cable, which stands for multiple unit. And so these cables are what transmit signals, input and output signals from locomotives in a consist. So they all essentially follow the lead locomotive with whatever the engineer is desiring that the other locomotives in the consist do. And if you look at the connected end of that MU cable, you can see it's in the red pothead, which is the live pothead. The other one is not even in the dummy pothead, is just hanging there. And the loop of the cable is right in between the drawbar couplers. So this was found in August in Great Falls, Montana, and a similar situation to this actually occurred in Havre years past, where a cable was left in this condition and was pinched between the couplers in the drawbar and caused a runaway locomotive. It received notch 3 input and left the Havre mechanical facility and derailed in the Great Falls yard. So this was not only a defect, but it was a good coaching moment with the mechanical facility and BNSF, as their crew had just worked on this consist and had failed to notice this defect. And here's a list of wheel defects that were found. The 2 shells were found on the same coal train in Helena Yard, and the thin flange in the top left picture there was found in Whitefish, Montana. And that thin flange was found on a loaded LPG tank car. So obviously our program tries to focus on all Title 49 CFR 215 defects, which are wheels and anything that pertains to significant derail cause. And so wheel defects are always important to find, even more paramount on a hazardous material car. This is just a quick summary snapshot of our 2023 statistics. We performed 293 solo inspections. We have 2 inspectors, myself and Dave Jackson, on it located in Billings. In addition to the 293 solo inspections, we performed 41 joint inspections with the FRA. During those inspections, we identified 1,827 defects and issued 2 violations. This is a quick snapshot of the national train accident rate from 2014 to 2023 as of December 28th, 2023. As you can see, there was a small decline, 23 over 22, but still up considerably over the decade. And again, this is the national accident rate.
We were testifying here a few months ago. Burlington Northern testified right after I did, explaining that the incident rates were down significantly over the past few years. So this is in direct conflict with what they told us.
Mr. President, Commissioner Finocchi, this would be the national train accident rate across all railroads. So BNSF is one class 1. So I do not have the statistics for just BNSF.
Well, it seemed to me that the incident rate for Burlington Northern has increased in Montana just here lately. So I was kind of surprised about his testimony. And I'm hearing, on national news, the incident rate is up across the country, which this report certainly supports. But there was no mistake. Burlington Northern testified that the incident rate is at an all-time low. I just thought I'd point that out, that was interesting.
The next slide shows specific to Montana accident trends on the top of that chart, 2010 to 2023. You can see, no surprise, Montana, along with the industry standard #1 and #2 cause of derailments. If you follow the purple line and the orange line, human factor and track cause. One significant note on this chart, 2018 was the last time that there was a equipment-caused FRA reportable derailment in Montana, and equipment is what we regulate at the PSC in our MP&E discipline.
That's a good fact, Mr. Sherwood. Congratulations.
Yes, thank you, Mr. President. This next slide shows railroad track miles per state. As you can see, Montana is the largest state in relation to track miles. And as mentioned previously, we have one of the smaller programs as far as railroad inspectors. We have 2 MP&E inspectors. All of the other states, with the exception of Idaho, which has significantly less track miles, is involved in more disciplines than Montana is. And that is it. Happy to answer any questions.
Commissioner Pinocci?
So can we go back a slide? where we show the miles. The most extreme weather of any of those states would have to be Montana, because we can go from 50 to below to 100 above, which causes, well, 6 inches of expansion and contraction, I think, every mile. And I'm hearing that we've had some problems due to derailment to that problem. And I would think Montana's should have a little more assistance, because we have to deal with that extreme weather shift of over 100 degrees, which causes expansion and contraction in the lines. They tell me Havre, large derailment there. It's also, they call it sun kink, because a lot of my engineers refer to it that way. Do you feel that of all these states that we have the greatest challenge of that temperature and expansion and contraction? Can we get extra help because of that?
Mr. President, Commissioner Panochi, to clarify your question, extra help in the sense of additional inspectors, or?
Yeah, let me practice with you there. Engineers working with me have told me that that's a big challenge in Montana. And that they feel at least 2 derailments have had to do with that. They're telling me that when we go from, say, 0 to 40 or 50 below, which could happen in the next few days, that there'll be a problem of contraction. Then when we start heating back up, 50, 60, 100 degrees, there's a real challenge to inspect track at that time. We simply can't do it. We just don't have the manpower. This state of Montana has a particular challenge of that temperature variance over the other states. So the question they say to me is, when we have that kind of temperature shift, we should probably inspect all track before we get back on it. We simply can't do it. And then as a result, we run into that problem. Has that point of view been brought up to where that's something we can ask for? Or do you think that that concern is not one worth bringing up? What are your thoughts there?
Yeah, a good question, Commissioner Panochi, Mr. President. I would concur that the significant weather changes in Montana are cause for potential increase in safety concerns, not just in track, but also in mechanical. That metal allergy of the wheels can, it's common after rapid temperature change that we see more decisive shells and flat spots on wheels that are common to follow the trends. But I would agree that the track department faces the biggest obstacle in drastic weather changes. And I know that the railroads themselves have a voluntary standard anytime there's a large temperature swing to perform continuous track inspections. So they will inspect anytime. For instance, in the summer when it's over 90 degrees for the first time that year, they will have a track inspector on that track the entire time it's over 90 degrees. And similarly in cold weather, say first time below 20 below 0, they will do that. But that is a voluntary action by the railroad. There's no regulatory standard at this time.
Well, I'm hoping, and I've asked this question and the engineers aren't really certain. They wanted me to ask. The priority should be trains that transport passengers, that during that temperature shift, that is the priority. And they feel that that's what didn't happen with the accident a couple of years ago, which was the most serious accident in the history of Montana. Also, there's a lot of talk about railroads transporting more people than ever. They're talking about bringing transportation of passengers between Bozeman and Helena, Helena and Missoula, Missoula and Kalispell. Those tracks are really going to have to be looked at closely, because there's a different way of inspecting rail from cargo to passenger. So if what they're saying is going to develop, I think that we're going to have to double or triple the amount of inspectors we have. And I don't think anyone really thinks about that when they're raising their hands saying, we're going to start doing passenger locomotives throughout the state. So this is a good time for us to say we could start identifying those tracks now and start bringing them up to a higher code before they start implementing that plan. And then, does our office here need to maybe double or triple the amount of people we have? Because you're saying we're going to expand passenger in a state that has the most extreme weather, probably in the United States. Alaska doesn't have the extreme warm. Montana can be 50 below, 80 below with wind chill to 100 above. So if we're going to increase passenger, which is I'm hearing stories all over the state, that's something that I think our office could be prepared to talk to the legislation about. And I certainly would be with you when we do that. Thank you.
Any other questions?
Yeah, Mr. President,
Vice President
Yes.
Fielder?
just a clarification while we're on this slide. For the viewers, Dan, can you please describe what OP stands for?
Yes, Vice President Fielder, Mr. President, OP stands for operating practice. And so that on the previous chart with the human factor, OP is the regulatory discipline that would basically observe engineers and switchmen that they're complying with their regulations for safely handling a train.
Thanks for that explanation. A follow-up, Mr. President.
Follow
up. Which discipline, if any, inspects the structures such as the trestles and the bridges and the tunnels and things like that themselves for integrity?
Mr. President, Vice President Fielder, good question. So typically that is done in the track department. However, the FRA does have a separate bridge and building department that they utilize specifically for bridge structures. My intent, as I have said previously to the legislature, is that if we were to add a track inspector in our program, we would be additionally certified in bridge inspection.
Okay. Thank you. And is it fair to say that the biggest obstacle to being able to perform these additional inspections within the state of Montana is we do not have the manpower to do it at this time? We don't have the FTE available for this program?
Mr. President, Vice President Fielder, that is correct, yes.
Thank you. No further questions, Mr.
questions. Thank you, Commissioner O'Donnell.
Thank you. Dan, go back to the very first slide. Where is that picture in Montana?
Mr. President, Vice or Commissioner O'Donnell, no, it is not. It's British Columbia, I believe.
Oh, darn. Okay, it's a great picture. Going on to the Paradise derailment, I'm looking at it's a great picture. Thank you for including that. And you said that there was a vertical defect was found in the track. As I traverse the state, I see the equipment. I think of the name of the company is Sperry on the side, running up and down the tracks. Are they doing some type of inspection, thermal or sonic inspection of the tracks?
Mr. President, Commissioner O'Donnell, that is correct. Yeah, they hire Sperry as a contractor. They call it a rail detector, but it's performing ultrasonic tests of the rail as it crosses over, looking for defects similar to this one, where there's a pre-existing fracture of the rail.
So, do you have any idea in terms of all the rail in Montana and how often? What's the minimum amount that a rail would be inspected?
Mr.
Like
President,
2 times a year, 3 times a year?
Mr. President, Commissioner O'Donnell, I know that the track inspections performed by the railroad are done twice per week. As far as the ultrasonic inspections, there is a minimum requirement. I am not sure what that is. If I were to guess, I would say 3 to 4 times per year.
Okay, that's good. So the fact that this particular picture you have right here, that this was missed, that would be a pretty extraordinary anomaly.
Mr. President, Commissioner O'Donnell, I'm not sure as to the timeline of the last ultrasonic inspection, but I would say this defect did not occur prior to the last ultrasonic inspection. So this defect had occurred in between the last ultrasonic inspection. Safe to say that it was there during the last track inspection, though. If that makes sense. Differentiating between the two.
Do you or does anybody have any information as to what the ultrasonic inspection finds? Is that totally proprietary with BNSF?
Mr. President, Commissioner O'Donnell, I believe that we would be privy to that information if we request it.
I'd really be interested in terms of what the railroad finds and how quick they are to fix that. I think that would be interesting. Perhaps not important, but it certainly would be interesting information, and not just for us. I'm looking at information being made available to the public in Montana. Certainly, derailments pose a significant threat. Larger or smaller, depending upon the location, to the general population in Montana. So I would like to find that information. Going down to the read point derailment, the next slide right there is that the primary cause of the catastrophic failure of the middle bridge abutment. Well, that seems to be pretty accurate because it's missing entirely. So it went away. And I think there was a previous question about whether or not who has responsibility for checking those abutments for the water rushing through there and causing some problem to the integrity of those abutments. Can you elaborate on that a little bit more?
Mr. President, Commissioner O'Donnell, the railroad is the responsible party for bridge inspections. As I mentioned, they as well have their own bridge and building department similar to the regulators. And so they have a bridge department that inspects the bridges across their line periodically throughout the year.
Okay, so this was a very large abutment. If it's the same size of the ones that are obvious in the picture right there, and the ones that I see in Billings with the railroad tracks going over, they look like they're really, really good, strong, permanent fixtures. But obviously something happened to that one. So you're saying that the state government does not have any oversight over that as well?
Mr. President, Commissioner O'Donnell, as our program currently sits, that is correct. We regulate MP&E, and so we do not have any enforcement authority over bridge or track structure. Wow.
And you're saying in response to Commissioner Fielder, I think that if we had an FTE that would, I think you're talking about rail inspector, but also with abutments. So you're talking about somebody who would be like scuba qualified to, I mean, that would be an underwater investigation, wouldn't it?
Mr. President, Commissioner O'Donnell, the purpose would be to, the goal and objective would be to get a track inspector that is secondarily authorized in bridge structure. As far as underwater inspections, that is a little beyond the scope of even what the FRA does. So the primary inspection of the bridge would be the bridge structure itself.
Okay. going on to the, by the way, is that bridge, it looks like it's, as I pass by it, that it's reconstructed, it's operating, but it's in different sections on the whole thing. It looks different from one part to the next. Is it anticipated they're going to build an entire new bridge across there and abandon that one?
Mr. President, Commissioner O'Donnell, that is correct. I know BNSF has plans to redesign the track structure and that bridge. There's a significant curve just east of the bridge, and so it's not causing the best train alignment and causing undue force on the rail entering the bridge. So their plan is to redo the track segments on both sides of the bridge and make it more tangent so that it has less vertical or horizontal force on the rail entering the curve of the bridge. But I believe that's a 2 to 3 year program to get that bridge. So it's a fairly long-term temporary structure that they have.
All right. And do you happen to know, is there any requirement, a state requirement or anything to completely remove the existing obsolete bridge and abutments?
Mr. President, Commissioner O'Donnell, I believe that is BNSF's plan upon completion of the new bridge.
Good, thank you. Going down to the River Road East fire, you're saying that alleging the fire was started by the railroad. What does that mean? That the equipment was faulty, or was it normal operations? Certainly, we don't have coal-fired trains with sparks coming out of a stack anymore. But what are they saying? What are they alleging was the specific cause of the railroad starting the fire?
Mr. President, Commissioner O'Donnell, I have not reviewed this lawsuit personally. I have just been working with the FRA as far as data collection on locomotives and cars that have traversed it. So obviously a defective condition would have had to cause this if the railroad is at fault. So that defective condition could have been a worn out brake shoe with the brake heading, with the brake rigging, rubbing the wheel, causing a metal on metal friction spark, or defective turbo, fuel pump, etc., from the locomotive causing sparks out of the stack. So we have yet to find any evidence that's indicative of railroad causation.
Mm-hmm. Okay, thank you. The next one about MRL, is MRL cease to exist? Did BNSF assume all of the rolling stock as well as the leases?
Mr. President, Commissioner O'Donnell, that is correct. So the lease was terminated by MRL. BNSF has retaken over what was their line originally. It was under a 60-year lease to Montana Rail Link. My understanding is Montana Rail Link has retained some of the smaller subdivisions. For instance, a small subdivision that goes to Montana City to service Ash Grove, a subdivision that goes to Harrison, Montana. I'm not sure exactly how that will work out contractually between BNSF and Washington corporations, but Montana Rail Link is no longer operating as a railroad as of January 1st, 24.
Very good, thank you. And then let's see if I had any, going down to the areas where the wheels themselves are delaminated. Is that the term? This is slide number 10.
Yes, sir.
Okay. So does that indicate any deficiency in the quality in the construction of that wheel, or is that absolutely normal? And the second question would be, if that proceeds to increase, what ill effect would that have on the operation of that car and the safety of that train?
Mr. President, Commissioner O'Donnell, yes, it's a fairly common defect, as I mentioned previously, especially in the colder weather conditions. It is a defect in the wheel itself, and the primary danger of this shell spot not being, or this wheel not being removed from the train with a shell spot this significant is impact rated in kips to the track structure. So as in the Paradise derailment example, if you have a rail that already has compromised integrity, when this wheel comes down and hits the shell to the rail, it's no longer the same force as a smooth wheel. So the coefficient of friction on a horizontal surface is changed by the structure of the wheel, causing a heavy impact, which could further break the damaged rail.
Very interesting. Can a wheel be replaced off of a car without taking it into the repair yard? Could it be replaced on site without decoupling it from the rest of the train?
Mr. President, Commissioner O'Donnell, that's a good question. The railroads are working toward situations where that can be accomplished. However, it's very, very specialized applications. I know there's certain yards. BNSF is creating jacking pads, and they've got specialized equipment that can actually lift a car in train, change out the wheel, and lower the car. But that being said, it's only being done kind of in a test operation on certain tracks, I believe in 1 or 2 yards. So outside of those 2 specific examples, neither one of which are in Montana, the wheels would have to be removed from a repair track after being removed from the train.
Wow. In inspections that throughout the whole year, for instance, how many wheels would you find that failed that delamination test?
Mr. President, Commissioner O'Donnell, I would venture to guess of the 1,800 defects that we found last year, at least 200 of them would have been wheel defects, would be my best guess.
And is it my understanding that from your report here that you do your inspections only for trains that are at rest within yards?
Mr. President, Commissioner O'Donnell, we do our inspections at trains in rest, not necessarily in yards. We will perform inspections in sidings or in outside of industry tracks, etc. So not just in yards, but obviously all on sitting trains.
So do you do your inspections just whenever you can, or does the railroad have to submit have to have a car available for an inspection? How are the inspections done? Is it random or is it organized ahead of time?
Mr. President, Commissioner O'Donnell, I review data so this month I'm reviewing data from 2023 to try and identify any trends for a high level of derailments or accidents in a specific area. And then we will come up with a data-driven plan as to the priority of each county in relation to inspections. For instance, Hill County and Yellowstone County have historically been high cause for accidents just because of the nature of how they're handling cars in those yards being major classification yards. So we will review data and then create a plan systemic to that data as to the priority of the inspections. But our goal is to inspect trains across the entire state, obviously.
Well, I'm thinking, are there trains that just simply originate outside of Montana, traverse Montana, and don't do any stopping at all?
Mr. President, Commissioner O'Donnell, I do not believe that any intrastate traffic that traverses Montana would never stop in Montana. For instance, even the coal trains that are extended haul stop at least once in Laurel and in Missoula, either in Missoula for the eastbounds or Laurel for the westbound. So even the trains that have a waiver for extended mileage are stopping once in the state.
Okay. I guess just one other question. There was a public testimony at the beginning of the meeting today. I don't know if you were present on there. And as far as I could understand from the lady, she was talking about the extended periods of time, in excess of 15 minutes, trains that are stopped blocking roadways and the impact on emergency vehicles. Could you respond to her testimony? First of all, were you there? Were you present for that?
Mr. President, Commissioner O'Donnell, yes, I was in the room for the public comment, and it is an issue, I will say, not just at Headlane Crossing, but crossings across the state that we are working to mitigate the issue. It's going to be a slight transition now as that specific crossing has just changed into a new railroad via the merger and the lease termination. But it is our goal to rectify that situation. I mean, the railroads know the regulatory stipulations that they have for block crossings, and it's our purpose to enforce that regulation.
Thank you. I think Mr. Jackson pointed out to me several years ago that efforts that is a big problem, especially in rural areas for emergency vehicles, being that there is not exactly an abundance of roads in the area for emergency vehicles to use. And the impression that I've gotten is that the railroad seems to say, you know what, we'll just do our operations, and if we block any access for emergency vehicles or for people trying to get to different sections of their property that the railroad has cut across, that's just tough. That's the impression that I've gotten. Is there any headway on that in terms of state legislation or federal legislation?
Mr. President, Commissioner O'Donnell, I can't speak directly as to the comments the railroad has made or insinuated. I do know that there is some gray area as to federal preemption as it relates to block crossings, specifically with intrastate versus interstate trains. And I know that is an ongoing discussion as far as regulatory authority on intrastate trains after federal preemption.
Very good. Well, thank you, Dan. I think you're doing an amazing job. I certainly am impressed with the work that you and Dave are doing, and I'm very proud that this commission has two people such as qualified as you guys, who are simply not afraid to do your job accurately and to find a violation where it exists and not be beholden to the railroads. I know you have a working relationship with them. You have to. You're not the evil, wicked, mean, and nasty inspectors that come, but you do your job, they do their job, and I think you do it in a very professional way. And I'm really proud that the Public Service Commission utilizes you and Dave and your services. Thank you very much.
Well said, Commissioner Pinocci. I think all of your colleagues would agree with the sentiments you just stated. Commissioner Bukacek, any questions?
Oh, Mr.
No,
President,
sir.
I do have one other question.
If Commissioner Bukacek yields her questions to you.
I do.
Commissioner O'Donnell.
The effort to restore passenger rail service all over the state, could you tell me how that would affect the ability of this commission, of you guys, to do your job properly? Apparently there'd be a major change in track to accommodate different standards for passenger trains. And so that would probably involve the construction of an entirely different set of tracks. Do you have any idea, Dan, where this is going and what effect that would have on your department's ability to perform your job?
Mr. President, Commissioner O'Donnell, as to where it is going, where it's at, I cannot really speak. I, like you, have heard a lot of talk about it. I haven't heard anything or seen anything more than the proposed talk. I know that it seems to be gaining some popularity, but outside of that, I can't speak to whether or not it will or will not happen. As from our agency's perspective, since we are not regulating track at this time, the only changes that we would have would be more Title 49 CFR 238 inspections of passenger rail equipment, which we are already performing on the High Line, but it would obviously be substantially increased as far as passenger train cars and all that is in CFR 238.
So just to follow up on that would be, should that additional passenger rail service be restored to Montana, it would really necessitate an expansion of FTEs in your department, correct?
Mr. President, Commissioner O'Donnell, I would concur with that statement.
Thank you. Thank you, Mr. President.
Commissioner Nochi had some follow-up, I understand.
Thank you, Mr. President. Okay, so we'll focus on what we do. We can inspect equipment, and these bearings get pretty hot. So there's a sensor on the track that the train can pass over, and it can sense a hot bearing and notify through an alarm that this has happened. Could we, as a commission, start installing these sensors or requiring them to be used more often throughout Montana? And keep in mind, a train that is leaving the yard that's been parked overnight, everything is cold. The train that the sensor is going to be able to detect is one that's been on the track for a while. But I would think that any high traffic area should have them. I envision the Public Service Commission having a map of all the rail and a red dot where these sensors are. And then if a sensor goes off, your computer's notified, BN's is notified. Can we start doing more of that? Or could we take over where we install a sensor that could identify a hot bearing? What are your thoughts there?
Mr. President, Commissioner Pinocci, I know that the FRA, after the East Palestine derailment, is extensively looking at changing the regulation. Right now, they have a regulation that wayside detectors be installed and used, but no stipulation as to the distance between those detectors or the ways of handling a defect when a defect is notified by a detector. That being said, as far as our agency, I'm kind of speaking outside of my expertise, but I think that we would battle the preemption if we were to step above the FRA guidelines for wayside detectors.
Well, I think a good argument could be made if we're supposed to be inspecting wheel bearings, if we had the ability to put a sensor in to identify one that's hot, I think we'd be doing a pretty good job. Maybe we should ask the legislature if we get money for that. Maybe work with the railroad. Why would they mind if they had an extra set of eyes where they don't have them at all? Anyway, I just think you'd be able to do your job better. And if it's our responsibility to track those bearings, let us have the responsibility of putting a sensor in. That's my thinking.
Any additional commissioner questions? Seeing none. I would like to commend you, Mr. Sherwood, for your presentation. You are on top of your game, as you always are. And with you, Joel, thank you for your presentation. This was very informative, not only to the commissioners, but certainly for the public to understand these two areas of PSC jurisdiction. So thank you for sharing presentations. Just some public announcements. Tomorrow at 9 a.m., the Select Committee on Energy Resource Planning and Acquisition will be meeting at the State Capitol in room 137. And then our next commission business meeting will be Tuesday, January 16th, 2024, at a different time. We'll be meeting at 1:30 PM instead of the regular 9:30 AM. So time now being 11:54 AM and seeing no further business to come before us, I will adjourn today's business meeting.
Great meeting. Thank you.